Good morning, friends. My today topic is Sukhpal Singh Khaira versus the state of Punjab 2022, which was decided on 5th December 2022. The bench comprises of Honorable Justice Shahid A. Nazir, Honorable Justice Bhushan R. Ghoi, Honorable Justice Ajit Kutria S. Bopanna, Honorable Justice B. Rama Subramaniam, and Honorable Justice B.B. Nagarathan. Friends, the questions put before this honorable bench, constitutional bench were, can a trial court summon a new accused person under section 319 of the CrPC after the trial has ended? I am repeating the question. Can a trial court summon a new accused person under section 319 of the Criminal Procedure Code after the trial has ended? Second was, if in criminal proceeding against multiple accused, the trial has been separated between physically present accused and absconding accused persons, can a new accused be summoned in the second set of proceedings after the first had concluded? I am repeating the question. If in criminal proceeding against multiple accused, the trial has been separated between physically present accused and absconding accused person, can a new accused be summoned in the second set of proceedings after the first has concluded? Third question is, what guidelines must courts follow while summoning a new accused under section 319 of the code? What guidelines must courts follow while summoning a new accused under section 319 of the code? So, friends, let us first dive into the background of the case, then its reply and reasoning. Now, factual background first. A case was registered against 11 persons for offenses committed under various laws, including the NDPS Act 1985 on 31st October 2017. The Session Court convicted 9 of the accused and acquitted 2. On the same day, after the conviction, judgment was pronounced, the Session Court issued a summoning order against 5 additional persons under Section 319 of the CrPC. Now, friends, Section 319 of the CrPC empowers the court to summon additional accused if the evidence produced in the case suggests their involvement in the alleged offense, provided the summoned order issued in the course of any inquiry or trial. The newly accused individuals, now the petitioner, challenged the summoning order of the Punjab and Haryana High Court. The High Court upheld the summoning order, leading the petitioner to the Supreme Court. Before the Honorable Supreme Court, the petitioner contended that the summoning order can only be issued in the course of an inquiry and trial and cannot be issued after the conclusion of the trial, as it deprived the accused of the right to be informed of the accusation and defend themselves while evidence is being examined, which is the only possible during the course of the trial. The respondents contended that summoning an accused after the conclusion of trial was a mere procedural irregularity that should be excused in the lights of the objective of the section 319 to do complete justice. The issue was referred to a constitutional bench of 5 judges of the Supreme Court. Now, friends, decision of the Supreme Court. The Honorable Supreme Court determined that summoning order under section 319 of the CrPC is made in the course of trial. If in the case of acquittal, it is made before acquittal is pronounced, and secondly, in the case of conviction, it is made prior to final sentencing order. If the summoning order and either the acquittal order or sentencing order in the case of conviction are issued on the same day, the facts and circumstances of each case must be examined to see if the summoning order precedes the conclusion of trial. The judgment of the court was authored by Justice Bupan. Where trial proceedings are bifurcated between physically present accused and absconding accused, the Supreme Court ruled that trial courts can summon additional accused individuals in the subsequent proceeding against absconding individuals if the evidence on which the summoning order is based on arises from the subsequent proceedings against absconding individuals. However, the Supreme Court ruled that the summoning order cannot be founded on evidence recorded in the main concluded trial against physically present people if the power under section 319 had not been utilized in the main trial until its completion. So I am repeating this para. Where trial proceedings are bifurcated between physically present accused and absconding accused, the Supreme Court ruled that the trial courts can summon additional accused individuals in the subsequent proceeding against absconding individuals if the evidence on which the summoning order is based or arises from the subsequent proceeding against absconding individuals. However, the Supreme Court ruled that summoning order cannot be founded on evidence recorded in the main concluded trial against physically present people if the power under section 319 has not been utilized in the main trial until its completion. The Supreme Court also established guidelines to be followed under section 319 of the CrPC. Some of the key guidelines it laid down are: if during trial evidence or an application implicates another person in the offense, the court must pause proceeding and first assess the need to summon the additional accused and issue summoning order if deemed necessary. The decision on joint or separate trial for the summoned accused is then made with a joint trial commencing only after securing the new accused presence. If the power is invoked after judgment is reserved, the court should set the case for rehearing following the specified procedure, and even in the event of joint trial, it should be conducted afresh, and if a separate trial is decided. Proceeding with the summoned accused can proceed after pronouncing judgment in the main case. Now, let us dive into reasons for decision. The object of section 319. The Supreme Court found that section 319 of the court was introduced to ensure that the accused, not initially charged sheeted, but found to be involved in the crime during trial, does not escape legal consequences. This section empowers the court to summon and try such an accused along with others before the conclusion of the trial. When the trial ends, as the summoning order can only be issued in the course of trial, a key question was when trial is deemed to end. The Supreme Court observed that a trial ends at different points, depending on whether the trial ends in acquittal or conviction. In case of acquittal, the court will record an acquittal order under section 232 or section 235 of the CrPC, and trial is concluded. However, in the case of conviction, after the judgment ordering conviction, there is also a subsequent sentencing decision. Thus far, cases that end in conviction, the trial is not complete upon finding of guilt. It continues until the judge determines the appropriate sentence and pronounces the judgment. Additional accused can be summoned in separate trial, provided evidence produced in that specific trial indicates accused involvement. The Supreme Court clarified that mere bifurcation of trial engaged and absconding accused does not automatically validate an order under Section 319, summoning an additional accused in the earlier concurrent trial against physical present individual. The exercise of such power depends on the evidence recorded in a specific case indicating the involvement of the accused to be summoned. If in the split case against the absconding accused, evidence against absconding accused points to the involvement of another person, Section 319 can be invoked in that split case before its conclusion, but not based on evidence produced in the earlier concluded main trial. That's all. God bless you all. See you again.